When we total it up, we see that you've incurred over $8,000 in attorney's fees. Do you think it's reasonable that your daughter's father goes to jail over this? Ma'am, do you understand that in your amended enforcement petition, you asked the judge to put him in jail over this?
I understand that.
Is that a slap in the face to you?
Yes.
Are you struggling to make your bills on time?
Yes. He told me that his second luxury vehicle he purchased was a gift, a client gift.
So Mr. Sykes is driving a Porsche around, but he can't seem to make his child support payments on time.
The court is not going to punish someone for substantial compliance. So the motion for enforcement is denied. All right. We're on the record in cause number DF 2404935. Counsels, will you please announce for the record?
Yes, good morning, Judge. Attorney Alexis Linval, here for respondent Justin Sykes.
Thank you all so much. Will those who intend to testify please stand and raise your right hand? Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. You both may be seated. We're here today on the first amended motion for enforcement of child support that's been on file with the court since February 25th of 2026. Is that correct? All right. You all will be given, prior to that, we spoke about some exhibits that were pre-admitted. They will be admitted at this time. So movements 1 through 4 are admitted and respondents 1 through 7 are admitted. You all will have 15 minutes aside, and that will include any opening and closing statements should you all choose to make them. Attorney Berline, Attorney Berline, would you like to make an opening statement at this time?
I would briefly, Your Honor.
Okay, you may proceed.
Okay. Your Honor, this is our enforcement, mother's enforcement. It's a child support enforcement, Your Honor. We are alleging 15 separate violations of late payment of support. The order that's on file in this case requires child support to be paid on the 1st of each month. And on 15 separate occasions, respondent has failed to pay child support timely. Respondent might say in this case, well, I've paid all of my support and this motion is frivolous. However, I would reiterate to the court that the Fifth Court of Appeals in Dallas has said the fact that an obligor may not be in arrears in child support payments at the time of contempt hearing does not excuse the fact that he has not made the support payments on the dates on which the payments were ordered due. And that's exactly what we have here, Your Honor. The late payments have caused my client trouble paying her rent on time, getting groceries for her child, and we need it to stop. We need payments to come in on time. I'll pass. Thank you, Your Honor.
Thank you. Counsel, would you like to make an opening statement?
Yes, Judge, briefly.
You may proceed.
Your Honor, this is not a contempt case. The decree defines delinquency as more than 30 days or a month of unpaid support. Out of the 15 violations mother alleges, this has happened one time. However, every payment was made, and in fact, we believe that the evidence will show that my client has actually overpaid at this point. The OAG financial activity report and the OAG record and both parties' evidence confirms this. What we have here, Your Honor, is a timing dispute. We are talking about days, not defaults. This is not willful compliance or willful non-compliance for the purposes of contempt. Accordingly, Your Honor, we are here asking the court to deny Ms. Sykes' enforcement and award my client all of his attorney's fees incurred in me having to be here today. Thank you.
Thank you. Counsel, you may call your first witness.
Thank you, Your Honor. I'm going to call my client, Area Sykes.
Ma'am, if you just have a seat right here and just pull the microphone closest to your mouth.
It said there wasn't a signature.
It's on page 9. Counsel, whenever you're ready.
Thank you, Your Honor. Ms. Sykes, can you please state your full name for the court?
Yes, it's legally Ariel Park.
Thank you, Ms. Park. There was an order for child support entered in your case back in December 19th of 2024. Is that correct?
Yes.
Okay, and it ordered Justin Sykes to pay you $14.72 in current child support.
Yes.
Okay, and it also ordered him to pay you $305.79 in cash notes.
Yes.
And what was the due date for those payments?
The first of every month.
Okay, and those payments started back in November of 2024.
Yes, that's correct.
Initially, how are you receiving child support payments from Mr. Sykes?
Via Venmo or Zelle.
Was there a reason why he was paying you directly?
Yes, he said I should not sign up through the OAG because payments would be late, probably about a month late. If we pay through the portal.
Okay, and he did pay you informally for a period of time, correct?
Yes,
Was that period roughly November of 2024 to May of 2025?
yes,
And you're not disputing that you received those payments?
I'm not disputing that.
You're willing to give him credit for those informal payments?
Yes,
Were any of those payments made on time?
I think the first couple were made on, the first two.
Okay, can you take a look at what I have marked as mom's exhibit 1 in front of you?
Yes,
You recognize that?
yes,
Is this an affidavit of direct payments that you completed?
yes.
Okay, and take a look there for me and tell me how many payments that you admit were paid informally were made on time.
One payment was made on the first.
Okay, after May of 2025, did you start receiving payments formally through the state?
Yes, I did.
Have any of those payments been made on time?
No,
I want you to look at what I have marked as mom's 2. Do you recognize that document?
yes,
And is that a updated child support payment record that we've received from the state of Texas?
yes,
Okay. Do you see any dates listed there which show child support payments made on the first of each month?
no,
Is Mr. Sykes employed?
yes.
Is he employed for a company or is he self-employed?
He's self-employed.
And in your order, there was a suspension of withholding, is that correct? Are his payments ever withheld from his paychecks withheld?
I'm not sure what that means.
Does he have an employer that can withhold the child support amount from the paychecks before he gets them?
No, he does not.
Okay, he's self-employed.
Yes,
So he gets to determine when he makes the payments.
yes,
Okay, want you to look at mom's 3. Are those proof, is that proof of the Venmo payments that were made or Zelle payments made directly to you?
yes.
Okay. What happens when he pays the child support late?
I cannot pay my rent on time and I incur eviction notices and late fees through my apartment
And how often does that happen?
nearly every month.
Okay. Has it given you trouble getting groceries, paying other bills and expenses?
Yes, absolutely.
Okay. And you're here today asking the court to order Mr. Sykes to pay by the first of the month.
Yes, please.
And we've also asked that the court order he pay a bond, and at the amount of at least $10,000, is that right?
Yes,
In the case of future enforcement or future late payments.
correct.
Okay. That's what we're sharing.
All right, Cross.
Yes, ma'am. Is your salary approximately $68,000 a year?
Is that before or after taxes?
Your salary, so before taxes.
Before taxes? No, I've gotten raises since that number.
Okay, so what is your annual salary, ma'am?
I believe it's, I just got an increase in March, so I believe it's 85,000 roughly.
Okay, you're earning $85,000 a year.
Correct.
I wanna look at the violations that you alleged in your first amended enforcement. For violation number 1, you're alleging that my client did not pay his December 2024 child support until December 2nd.
Correct.
And you said he paid you the support, but that it was 1 day late.
Yes,
Violation number 2, you allege that he paid your January 1st child support on January 3rd.
yes,
So you acknowledge that he paid you, but that it was 2 days late.
correct.
Violation number 3, you allege that he paid you, but he paid you on February 3rd instead of February 1st. Is that correct?
That's correct.
Violation number 4, you allege that he paid you, but he paid you on March 6th instead of March 1st.
That's correct.
Violation number 5, you state that your April 1st, 2025 or your April 2025 child support payment, that you didn't receive that until April 3rd.
Correct.
So he was 2 days late.
That's correct.
You're asking the court to hold him in contempt
Yes,
and potentially have him handcuffed and jailed like we just saw in the hearing before us.
correct.
When he's a couple days late on child support,
It's been actually 2 months.
objection, non-responsive.
Sustain.
When he's a couple days late on child support, you're asking for the court to have him incarcerated, ma'am.
It's been more than a couple of days, ma'am.
Objection, non-responsive.
Sustain.
I'm just talking about the violations that we just went over, violations 1 through 5.
Oh, yes, that's correct.
Violations 6 and 7, admittedly, payments were a little bit later this go around. We have May 14th and June 11th, correct?
Yes, that's correct.
And you acknowledged again that you received payment on those months
Yes, correct.
and within the month that the payment was due.
On May 14th and June 11th, what you said?
Yes.
Okay, I need to look at this. May,
Ma'am, you've received all the child support payments, correct?
I have not received May yet.
But we're talking about 2025. You have received May and June 2025.
Yes, correct.
In your own exhibit 3, and you just testified to the fact that my client has paid you directly, is that correct?
Yes, that's correct.
Okay. And have you had a chance to review the OAG financial activity report in this case?
Yes, I have.
Okay. And so you're aware that those direct payments are actually not reflected on the OAG financial activity report, correct?
I have submitted all the paperwork needed on my end. I'm not sure why it's not reflected on there.
But you agree with me that the payments that my client made to you directly are not reflected on the OAG financial activity report at this time, correct?
I don't know. I'm not in charge of that, so I don't know why they haven't reflected.
And the binder in front of you, that's a skinny white binder, if you would grabbing that for me, please, ma'am. In turn to tab 1 for me, please, Father's Exhibit F1. You acknowledge that you received this letter through your attorney over 2 months ago, correct?
Correct.
And it asked you to non-suit your case,
That's correct.
and you chose to anyways, correct?
That's correct.
It asked you to sign a direct payment affidavit to reconcile the OAG log to reflect payments made to you directly, correct?
I had already done that.
Okay. Did you or your attorney ever tell us that you had submitted that to the OAG prior to coming here today?
I believe so. We spoke about that, my attorney and I.
But you don't have any evidence here today that that was provided to us and told to us that it was submitted to the OAG, correct?
I don't believe that that's under my jurisdiction.
So ma'am, would you agree with me if the OAG payment log shows that he's about 1 month behind on child support? You agree with me that that's the fact right now, right?
I'm sorry, can you repeat that, please?
Sorry, that was a confusing question. You agree with me that the OAG financial activity report currently reflects that my client is 1 month behind on his support obligation?
To my knowledge, he is 1 month behind.
And you agree with me that there are a handful of payments that you received that have not been reconciled on the OAG payment log at this time, is that correct?
I don't know the numbers. Whenever I go to see if they've corrected it, I still see numbers in that tab. I don't know what the total is.
Would you agree with me that if the OAG actually reconciled the accounting to reflect the payments that you received directly, my client would actually be overpaid in child support at this time?
I don't, and I don't know where that number came from.
Objection, non-responsive.
Sustain after I don't.
Violation 8 and violation 9, ma'am, of your amended enforcement. You claim that you received the July 2025 child support, but you received it on July 15th, correct?
That's correct.
And you claim that you received the August 2025 child support, but you received it on August 19th, is that correct?
That's correct.
So again, you're not complaining that you didn't receive that child support. What we have here is another timing issue, correct?
That's correct.
Exhibit 4 consists of your attorney's invoices. When we total it up, we see that you've incurred over $8,000 in attorney's fees, not including what you're incurring today. Does that sound accurate?
Yes.
And yet it's possible once the OAG reconciles payments that you've received directly, it could show that my client has actually overpaid you by near that same amount.
That is incorrect.
I don't have time to go through all the remaining violations with you, ma'am, but just to be clear, you have received all of the monthly child support payments that you're owed at this point.
Up until May, yes.
May 2026.
May 2026, yes.
Ma'am, do you think it's reasonable that you've incurred over $8,000 in attorney's fees when there's a possibility that you've been overpaid child support?
I don't believe there is any possibility that I have overpaid child support.
Okay, say for the sake of conversation that you have not been overpaid child support. Do you still think it's reasonable that you've incurred $8,000 to be here today when you acknowledge that you have received all of the payments that you're owed except for one?
I do, because I've made.
Objection non-responsive after I do.
Sustain.
Do you think it's reasonable that your daughter's father goes to jail over this?
I would prefer he not go to jail.
Ma'am, do you understand that in your amended enforcement petition, you asked the judge to put him in jail over this?
I understand that.
Do you understand my client's self-employed?
I understand that.
And so you understand that you will absolutely not receive child support timely and likely not at all if he is incarcerated.
I understand that.
And you're here requesting that anyways.
I would prefer he's not incarcerated. But yes, I understand that's part of this.
Okay, counsel, you have exactly 4 minutes and 58 seconds left. Attorney Berlin, you have 13 minutes and 2 seconds.
Ms. Sykes, we filed a proposed order in this case, is that right?
Yes,
And we asked that the court suspend any commitment of Mr. Sykes, is that correct?
I'm sorry, can you?
We asked the court to put Mr. Sykes on probation, is that correct?
Yes,
Now, you're aware that, counsel brought up the issue of the letter that she sent to us. You recall that question?
yes,
You're aware that prior to that letter being sent to us, I contacted Ms. Linvall. Is that
Yes.
correct? And I talked to Ms. Linvall about the potential to settle this case.
yes,
Okay, and I wasn't able to do that.
correct.
And essentially, Ms. Linvall's letter was a demand that we dismiss our case.
Yes,
Wasn't a settlement letter. It was a letter demanding that we dismiss our case and she won't go after her attorney's fees.
yes.
Okay. How often have you brought this up, this late payment, Mr. Sykes?
It's been multiple times, pleas, emails, texts.
What happens when we bring it up to him?
He tells me that I can take him to court and I can demand to take care of it.
Does he take you seriously?
I don't think so.
Even after we filed our case, did he continue to make late payments?
Yes, he continued to make late payments after we filed our case.
Even after we amended our petition in this case, did he continue to make late payments?
Yes, that's correct.
Has he ever made any payments on time outside of the first payment that he made?
No,
Are you claiming that you haven't received all of the child support?
I'm not.
What are you claiming?
I'm claiming that I would like him to pay me on the first of each month, or as close as possible, or at least give me notice to when to expect that I can receive my child support payments.
You believe the court order should be followed exactly to a T?
Yes,
And if the court order were to be followed exactly to a T, when are the payments due?
first of every month.
Okay. Have there been occasions where Mr. Sykes has been over 30 days late on payments?
Yes,
How often has that occurred?
2 times, 2 months.
You recall when those months were?
Yes, September 2025 and February 2026.
February 2026, so this year,
Yes,
filed our enforcement.
yes,
He paid over 30 days late.
yes,
Was that a slap in the face to you?
yes,
Are you struggling to make your bills on time?
yes.
What does Mr. Sykes do for a living?
He's an interior designer.
Does he work for Home Goods?
No, he works for very high-end residential, primarily residential projects and clients.
Does he make good money?
Yes,
Okay, you used to be married to him, correct?
yes.
Okay, and you separated back in 2023?
Um,
Let me rephrase that. You were divorced back in 2023.
2024, December 2024.
Right, okay.
Is
No, you're right. Thank you for clarifying that. Do you recall how much he was making per month at the time you guys were married?
he said he was making about 20 to 25,000 a month,
And so more than you, right?
much more.
Okay. And has he made any recent purchases?
Yes, he's
Objection relevant.
What's the relevance?
Your Honor, she called my client's income into question, implying that she can afford to receive these payments late, I guess. I think it's relevant for us to show that Mr. Sykes has the ability to pay on time, he just is choosing not to.
Okay, well, you said recent purchases. That could be anything. That could be gas. Okay, go ahead.
Has Mr. Sykes purchased expensive recently?
Yes,
Objection, speculation.
Would you like to take her on the voir dire?
Yes.
Go ahead.
Ma'am, you agree with me that you've been divorced from my client for over a year now, correct?
That's correct.
Okay, you're not privy to his finances anymore, correct?
That's correct.
You don't go with him to look at vehicles or visit car lots, is that correct?
That's correct.
You weren't there if he were to purchase the vehicle while he was signing the paperwork, correct?
Correct.
So you actually have no knowledge regarding how much a vehicle that he purchased would have cost, correct?
Correct.
Nothing further.
Your Honor, if I could ask one follow-up question.
Go ahead.
Has Mr. Science told you about purchases that he's made?
My daughter and Mr. Sykes have told me about 2 vehicles.
Objection, hearsay as to what her daughter has told her.
Sustained.
Sorry, Your Honor.
You have one more question go ahead.
With regard to what Mr. Sykes has told you, what has he told you about the vehicles he purchased?
Yes, he told me that his second luxury vehicle he purchased was a gift, a client gift in exchange for work. The client was unable to pay a past invoice and so gave him his Porsche.
Okay. So Mr. Sykes is driving a Porsche around, but he can't seem to make his child support payments on time.
And a Range Rover, yes.
So, non-responsive, sustained to non-responsive and overruled as to, relevance, right? Anything,
I'm absolutely sure.
okay, anything further from this witness?
No, Judge, thank you.
Okay, ma'am, you may return to your seat.
Thank you.
You're welcome. Counsel, you may call your next witness.
I'm gonna call myself, Your Honor.
All right, you may proceed.
I'm a licensed attorney.
I'll stipulate to opposing counsel's qualifications.
Okay,
Your Honor, I've submitted what I have marked as mom's exhibit 4, which is copies of our attorney fee invoices in connection with this case. We've had several exhibit conferences in this case, I think 2 exactly. I did amend my pleadings after this because Ms. Sykes was making the argument that her client, I think essentially she's making the argument that as long as her client pays the child support, it doesn't matter when he pays it, he can pay it late if he wants, as long as my client gets the money. And I disagree with that argument, Your Honor. And so I amended my petition to include case law that supports the fact that even if Mr. Sykes pays, it's not okay that he's paying late. The courts have considered.
Objection, Your Honor, I don't know how this goes to I don't know how this is relevant to the attorney's fees, it's more like oral argument.
sustain.
The point I was trying to make, Your Honor, is that I had to do research, and so that increased the costs. We did have to amend our pleading because of it. We did have to serve Mr. Sykes twice in this case. To date, not counting today, my client has incurred attorney's fees and costs in the amount of $8,563. We're asking that the court grant a judgment against Mr. Sykes in favor of my client for that amount of fees. I'll pass it with Sharon.
Thank you. Any questions for Attorney Berline?
No,
Okay, would you rest?
I do, Your Honor, if I have any time left, I'll reserve that cross examination.
All right, you have 7 minutes and 15 seconds left. Counsel, you have 4 minutes and 18 seconds left. You may call your first witness.
yes, thank you, Judge, I'll call my client, Justin Seats.
Okay,
Sorry.
Mr. Seitz, just pull them close to your mouth. And whenever you're ready to proceed, counsel.
All right, Justin, I want to quickly address a few things that were testified to. Did you tell Ms. Seats that she can take you to court if she wants to receive her child support payments on time or anything to that effect?
No, I said she could contact her attorney to contact you.
Do you receive paychecks?
I do not.
And there is an allegation or there was testimony that you paid late even after this enforcement was filed. Do you recall that?
I do.
And why is that?
Because I was coming up with money to pay the retainer for this case.
Have you been making your child support payments every month?
Yes,
And you acknowledge that your payments are sometimes a few days after the first.
that's correct.
Okay, now let's talk about when you're paying child support versus when it's reflected on the OAG report. My understanding is that there's a discrepancy there. Can you please explain that to the court?
There is the OAG records the payment process, a minimum of 5 days after the payment is actually made. So if I make a payment on the 1st every month, it's going to show the earliest on the OAG account as being paid on the 6th. There is no direct correlation to the date that I pay and the date that it's shown on the OAG account.
And is that substantiated by the evidence that has already been pre-admitted into court today?
Absolutely, all of my payments show that correlation.
Did you pay May child support yet?
Yes, on the first.
Okay, and again, as we sit here on May 4th, it is not reflected on the OAG's financial activity report. Is that correct?
Correct. It will not be reflected until at least the sixth.
Okay.
That's standard.
As we sit here today, are you behind on child support?
I am not.
Okay, do you believe that you are actually ahead as we sit here today?
I believe so.
Do you believe that once the direct payment affidavit that Ms. Sykes has completed is submitted to the OAG, that will actually show that you've significantly overpaid in child
I
support?
believe so.
Have you ever been more than 30 days behind?
I have, yes.
And when was that?
That was February of 2026.
You understand there's an allegation that you were more than 30 days behind in September of 2025?
Oh, it's not. I made the payment on September 30th and it did not record until the following month.
And again, your bank statements reflect the timing of that.
Correct.
Okay. When did you make that February 2026 payment?
I made it on March 1st along with the payment for March. So I think both at the same time.
Okay. And do you recall what date that you made that double payment for February and March of 2026?
On March 1st, and it reflected payment, I think either on the 6th or the 8th because of that OAG delay I was speaking to.
Just to give an example of this, if you look at tab 4 of the binder in front of you, exhibit F4, go 5 pages from the back for me. Are these snapshots from your bank statement? And Ms. Sykes alleges that you paid the September 2025 payment over a month late, correct?
Correct.
And when did that leave your bank account according to your statement?
It left my bank account on September 30th.
So even if you were to pay on the first of the month each month, you believe that she still would not receive it for approximately 5 days.
I am certain that's correct.
Why have you not paid child support exactly on the first day of the month every month?
I am self-employed and my cash flow is not steady. I don't take a typical paycheck. And so I make the payments when I do have the funds on a monthly basis to do so. And it's my first priority when I receive those funds.
Do you intend to pay every month?
I do.
Have you tried to stay current?
Yes, I have.
Are you taking steps to ensure earlier payments going forward?
Yes, ma'am.
Are you refusing to pay child support?
I'm not.
Ask the witness.
Right? Cross?
Thank you, Mayor. Mr. Sykes, you just testified that the September of 2025 payment that you made, it came out on the 30th, is that right?
That's correct.
Okay, and when was it due?
It was due on September 1st.
Okay, so it was paid 29 days late,
It was due on September 1st.
and you paid it 29 days late, correct?
I paid it on September 30th.
Okay, 29 days late, correct?
I paid it on September 30th.
Is that hard for you to admit that you paid 29 days late?
No, it's not. Because it's due September 1st. But based on our decree, it's not technically in default until after 30 days after the first.
Okay. So you think that date that says that you have to pay it on the first of each month, you think that doesn't apply to you, correct?
That's incorrect.
Okay. The rules don't apply to you, they apply to everyone else.
That's incorrect.
Objection, argumentative.
Sustain.
If it's your impression that you can't violate the order if you're not more than 30 days late, correct?
Objection, argumentative.
Sustain. Rephrase.
Is it your position that you can't violate the order as long as you're paying within 30 days of the due date?
That is not my position.
Now you've seen our pleading, correct?
Yes.
There's several violations, in particular 7 through 15, where we've alleged that you paid more than 5 days late. You aware of that?
Yes.
Okay. And so the issue that you're raising in relation to when the OAG processes the payments, how long it takes them to post the payments, doesn't apply to those violations, does it?
The dates that you're showing are still minimum 5 days after the date I actually made the payment.
May I approach witness turn?
Yes.
I'm gonna show you our violations here that we have in our amended petition, 7 through 15. Let's look at 7 through 14. Payments were due on first of each of those months, correct?
Correct.
Okay, and in June of 2025, the payment was on June 11th.
Is that what the OAG reflects?
You have my exhibit, Moms 3 in front of you. Do you have Moms 2, actually? Moms 2?
I don't have any of yours of this.
Should be in that stack to your right. Should be one that's marked Mom Exhibit 2.
Mom's exhibit 2.
Would you agree that this reflects when the payments were posted?
This reflects when they're posted, but not when they're made.
If it takes 5 days, like you said,
minimum 5 days.
okay. Would you agree that violations 7 through 14 show that you paid, there was more than 5 days, those payments were more than 5 days late, correct?
That's correct.
And my clients told you about this issue, correct?
We have discussed it.
Okay, and she make you aware that this is affecting her ability to pay her bills.
She made me aware that it affected her ability to go on a girls' trip.
Objection not responsive.
Sustain.
Did she make you aware that this affects her ability to pay her bills?
She did not.
Okay. And your response to her was that she needed to call an attorney.
This can be handled through our attorneys.
Okay. So you told her to seek out legal representation for this issue.
I did.
And she did that, correct?
Correct.
And that's why we're here.
That is not what we're here to do.
I'll pass it with the term.
Okay, counsel, you have 7 seconds left.
I was just gonna call myself for attorney's fees quickly,
Go ahead.
okay? My name is Lexi Limbaugh, I'm an attorney licensed to practice law in the state
Your
of
Honor,
Texas.
I'll stipulate to the qualification.
Okay,
Attorney's fees and costs incurred by my client attributable to this matter total $4,406. This does not include the preparation for and attendance at today's hearing, which is an additional $1,125 based upon 3 hours of my time here today. I'm requesting $5,000 in attorney's fees. My invoice.
thank you, counsel.
Thank you.
All right. Yes, I signed it. Thank you. Sir, you may return to your seat. The affidavit of direct payments, let me just make sure my math is correct. $17,711.11.
Your Honor, ours, I think is a little bit less than that. Ours shows 12,444.53.
12,000.
444.53.
Is that reflected now on the OAG's payment record?
It is not. Your
That's our
Honor.
understanding that it is.
That makes a difference.
And I think if we're looking at Ms. Limbaugh's F3,
Let me pull that one up.
it shows the credits.
So,
I see a $11,000 collection. Well, it's actually 3 collections there, October 5th, October 17th, and October the 22nd for about the amount that you said, counsel.
Correct.
and Your Honor, what I'm looking at is that it shows that there's a payment. And then on the financial activity report, there's not a transaction for September. So there are transactions that are reflected on both parties' direct payment affidavits that are not reflected in the OAG payment log.
Your Honor, I think that's because the order didn't start until November 1st of 2024.
So the direct payments wouldn't be on here. That were before that.
Right, so there's been payments made that are not reconciled with the OAG, and yet the OAG is only showing that he's one payment behind. He did make that payment. It's just hasn't shown yet because of the delay.
Right, and
I think those, sorry, I think the September payments were in relation to the temporary order that was in place at the time in the divorce case.
so what I'm looking at, the order says that the child support payments were supposed to start on November 1st, 2024. So if there was a temporary order, anything made prior to that would be for the temporary order.
That's correct.
Yes.
All right.
Just for example, Judge, like there's a one of the payments, like February 2025. For example, there was a direct payment made in February 2025, and then if you look at the OAG financial activity report, there's no collection showing for that month. So again, it's a direct payment made that is not reflected because Ms. Seitz has not submitted this direct payment affidavit, or at least we were not aware that it had been submitted until today's testimony.
I will disagree, Your Honor. I think those collections were made, looks like between 10 of 2025 and 10/22 of 25. It looked like they all were added to the record at that time, altogether totaled.
This is why I like for the AG to be present, because they can reconcile their own reports. Because I cannot say that someone violated an order knowing for sure if payments have been made, they have not been reconciled on here. Because according to this payment record that I'm looking at, Father's Exhibit 3, he would only be behind 1 month, and it would be consistent with his testimony as of the May payment not being reflected on here. And I believe I need that. In terms of holding father in contempt, I can't hold him in contempt at all. the rule is very straightforward about for child support, if you're seeking to hold in contempt, it must not only show the amount paid, it must not only show them due, it must also reflect the amount paid, if any. And in the motion, the violation doesn't specify the amount paid by respondent. It just said that his child support payment was due and he failed to timely pay. The court, in order to hold him in contempt, I would have to know what he paid, if anything. So if he made the payment of $1,779 or something less than that, the motion has to specifically cite that. So the court hold him in contempt. However, as far as a violation, at this point, with what I have in front of me, I don't even know if I can hold him in a violation, considering that the payment record that I have in front of me is not, it does not contain everything that the court needs for a violation, because from my purview, what I'm looking at, he seems like he's paying child support timely, monthly.
Yes, Your Honor, and just to clarify, our argument was not that he wasn't paying child support, it's that he's not paying it on the first of each month, which is required by the order.
Well, and here's the thing, the Attorney General wouldn't even bring a motion to hold him in contempt as long as the payment is made within the month. Although the order says on the first, as long as he makes that payment during the month, he wouldn't be held in contempt. It's not considered untimely unless he spills over into that next month. And to hold him in contempt for the way the agency updates, I just don't think that's right. So from what I'm looking at, I can't hold him in contempt or even a violation. Are there any other payments that are outstanding? I think the court needs those questions answered before I can even consider if a violation has even taken place, and I just don't have it in front of me.
I think there was at least one payment that was made over 30 days late, Your Honor. That was the recent payment in February. I think the testimony was that both parties admitted that that payment was made over 30 days late. I believe Mr. Sykes admitted that on the stand, and my client testified to that as well, February 2026.
Okay, I see that. Your bank statements reflect the timing of that, correct? When did you make that February 2026 payment? I made it on March 1st along with the payment for March. So I made both at the same time.
And for the record, Your Honor, February only has 28 days. And so he was still within 30 days at that point of when the payment was due. Also, there was testimony that he was paying me attorney's fees to have to defend against this contempt, which was part of the reason for the delay in the payment that month.
While those individuals are joining us, we'll go ahead and start through the docket. I'm going to go ahead and call the first case. At the, if you'll unmute I'm sorry, I've just muted you, so. Would you state your name, please?
Jeffrey Daniel Stewart.
Stewart, you have filed a pro se petition to have an administrator appointed for the estate in this case. And obviously, with you being incarcerated, you cannot serve, and I understood you acknowledge that, but you've asked for an independent person to be appointed. Is that correct?
That is correct, Your Honor.
Raise your right hand. Let's place you under oath so I can at least establish the basis for that. Do you solemnly swear from the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right, for the record again, if you'll state your name one more time.
Jeffrey Daniel Stewart.
All right, Mr. Stewart, the estate that you're seeking to have administration instituted is for Dwayne Ray Stewart. What is your relation to Dwayne Ray Stewart?
I'm his son.
All right, so this is your father.
Yes, sir.
And are there any other heirs besides you that are possibly involved in this estate?
Christopher Ray Stewart.
Is there anyone here in the courtroom who's also here on this estate, the Stewart estate? If you are, come up, please. And what is your name?
Christopher Ray Stewart.
All right. And you are also the son of Mr. Dwayne Stewart?
Yes, the oldest son.
All right. Mr. Stewart, both of you have acknowledged that you're potential heirs of this estate. And Mr. Jeffrey Stewart has requested that the court appoint an independent administrator of the estate. Do you have any objection to that?
Yes, I don't see that that's fit. I mean, he's been locked up, incarcerated for 10 years. I mean, I've been there with my father while he was sick, taking care of him, and I don't see how he can just come in and take over some things
Well,
like that.
Let me explain to you that this is not allowing him to take over. If I grant this request, it would be to appoint an independent administrator, probably an attorney here in Ashland City, to act as the administrator. Mr. Jeffrey Stewart will have no standing other than the fact that he was the original petitioner. Once I appoint an administrator, that administrator is the person who takes care of the estate, does all of the requirements to administer the estate. So I don't see how that would make him
That
in
would be
any way.
fine.
Is that all right with you?
Yes.
All right, then both of you having acknowledged that there was a need for an independent, Ms. Salinas, is she here? She's not here. We'll appoint, Ms. Brady, do you have any problems with serving as an independent administrator of this estate? All right, Ms. Brady is an attorney in good standing with this court. She practices in front of this court on a regular basis. She's very good at what she does, and I'm going to appoint her as the independent administrator of this case. And administrator ad litem, I think, is what we would be referring it to. So, Ms. Brady, if you will draw an order, and Mr. Jeffrey Stewart's address is set forth in the file where he's incarcerated. And Mr. Christopher Stewart, if you'll speak with Ms. Brady and give her your residence address so that she can mail you a copy of all the proceedings. Mr. Stewart, Jeffrey Stewart, I have granted your request to appoint an independent administrator. Margaret Brady has been appointed here. She will communicate with you by mail.
Thank you, sir.
All right.
Your Honor, this is James Doris.
Are you James Doris?
Yes, sir.
All right, Mr. Doris, you're here today because there's been a motion for default filed in the divorce action that your wife has filed against you. And we are proceeding in that case, but you are entitled, even though you're incarcerated, to be aware of this proceeding. It alleges that you, on the motion for default, it alleges that you were served with process on November the 24th, 2025, while you were in the Cheatham County Jail, and that you have not filed any answer, either representing yourself or with any other means. And as a result of that, the plaintiff in the case has filed a motion for a default judgment, which under the rules they would be entitled to.
Well,
Do you
Judge,
understand all that?
I have that, I did file that, and I do have a copy of it.
Did you say you filed an answer?
Yes, sir. Two or 3 days after the judge told me. I've got the copy. It says court.
All right, let me address you, Mr. Doris, so that you understand where we are. On January the 23rd of 2026, you filed something that you styled an appeal. It's a handwritten document. And it states, I, James Doris, am hereby filing for an appeal over the motion for default and notice of final hearing over my divorce. I was not notified that I had to file anything until I was released from jail in February. I still have not obtained counsel on my behalf over this matter at this time. I am requesting to settle this matter after my incarceration. I do not agree to anything that has been asked of or been requested by the plaintiff. Please accept my appeal and allow me this time. All right, then you also filed on March the 6th of 2026, a motion to compel. The above styled defendant, James Michael Doris, comes before this honorable court asking it to order marriage counseling to mend his marriage instead of ending it, and to do so through mediation of a professional, and also to appoint an attorney to Mr. Doris in this case as well. Then on March 13th, you filed a motion to oppose the divorce. I, James Michael Doris, wish to oppose my divorce. I want to mend my marriage through counseling. I need a copy sent to the judge over this case. I would like a copy sent back to me for my proof. Now, let me first address the request that the first document you filed, which was an appeal, a notice of an appeal. This court does not have the opportunity, does not have the power to compel you and Ms. Doris to settle your case. In other words, I cannot order that the two of you have to settle your case. There,
I
if
still
you,
love my wife.
pardon?
I still love my wife and my son very much.
We're gonna have to bring Mr. Doris into the courtroom, so just have Mr. Doris brought over as soon as we can bring him here, we'll can proceed with this case. We're gonna bring you over into the courtroom since you're in the Cheatham jail. It's more difficult to hear from you, when you're in the court, in the Zoom link, so we'll bring you over in just a minute.
Do what? What'd he say?
We'll get you brought up. Yes, Your Honor.
All right, let's try to see if we can get something simple. Moreland,
Your Honor, I'm standing on behalf of Ms. Jones, who's very sick today. She's asking the court to waive mediation and set this matter for final hearing.
there are two attorneys I show, Michael Durakowitz and Brandy Jones. And are they both in agreement to waive mediation? Do they have any reason why they want to waive mediation?
Well, just what she's put in here, the parties have made multiple attempts to reach resolution on this one limited issue and are likely to reach an impasse at mediation. Think they've made a partial asset distribution settlement and agreement, but they have the one issue of the equity from the proceeds of sale of the marital residence they've been unable to resolve. So they don't believe that it'd be cost effective to.
Well, I cannot waive mediation for one of the other judges, but I can waive it if necessary for
So in front of
myself.
yourself,
You'd be looking at November for the next time.
I will let her know that.
Do they want to obtain a date by contacting the clerk?
I assume so, Your Honor. She called me this morning and she was very sick. You could tell by phone, so
I can relate.
I understand. I'll let her know, Your Honor, to reach out to the clerk about a date in front of Your Honor solely.
All right, thank you.
Thank you, Your Honor.
You tell it's gonna be a good day when you can't even drink your water without spilling it. It would be a drinking problem. Would we consider that to be a judicial drinking problem? A motion to withdraw? Good morning.
National Bar, that's my motion to withdraw. Mr. Guy is here. I don't believe there's any opposition to us withdrawing. We're withdrawing at his request.
All right, so the motion to withdraw is set forth, based on the fact that Mr. Guy, you wish to, I'm sorry, yes, Mr. John Guy, is that who you are?
Yes, sir.
And it's my understanding that you no longer wish to have this law firm represent you and you want to hire new counsel. Is that
Yes,
correct? All right, well, I will grant you 30 days to retain new counsel.
Thank you, Your Honor.
Do I have to retain new counsel?
You don't have to, but if you don't, I'm gonna give you 30 days to retain counsel. You can either do that or not, but if you don't, then you're required to administer the estate yourself and file whatever's necessary to conclude it, okay? All right, you got 30 days to make that decision. Well, there's nothing to speak with. Basically, you're saying you know what needs to be done. So you've got 30 days to either hire a lawyer or get that done yourself.
Judge, this is a petition to probate the holographic will of Ophelia Underwood Brown. And before we get started on it, Judge, the original will was never filed. I've got that here, the copy file. She just produced the original today.
All right, and you have two independent non-party witnesses, non-beneficiary witnesses to testify about their handwriting.
I'm sorry, Judge.
You have your witnesses lined up to testify that this is their handwriting?
Yeah, I filed the copies when I filed the petition to probate. That's the original we're tendering to be.
I understand, but to administer a holographic or handwritten will, you must verify, you have to have witnesses, two independent witnesses that are not beneficiaries.
I've got
Okay, that's fine. That's all I'm asking you. So who is your client? Who is your client?
Linda Markham,
All right.
or Tanya, I'm sorry, Tanya Stewart. She is the daughter of Linda Markham, who was the original designated executor of the will. She's deceased, as is the other beneficiary in the will.
All right, so the beneficiaries under this handwritten will are Linda Helen Markham and Margaret Elizabeth Brown. Is that correct?
Correct.
So as a result of that, does that then pass to your client, Ms. Stewart? Would she be then the beneficiary of the will because her mother has passed, correct? And that's my point, so that we're clear. The statute is very clear that you cannot verify a handwritten will by the person who is going to take under that will. It has to be independent witnesses that would verify that the document is in the handwriting of the deceased and entirely the handwriting of the deceased. And Ms. Stewart is the daughter of one of the original beneficiaries, so she stands to be a beneficiary under the will. This has nothing to do with you, and please understand that I would be glad to do it, but the statute requires it to be independent. And the reason for that is because obviously you have a vested interest in trying to say that this is a valid will because you are a beneficiary to it. But an independent, we had one the other day that we had two people who verified the handwriting. Neither of them was taking under the will, but that's what is required. So, Mr. McNabb, I cannot verify this will or admit it to probate until you have those independent individuals that will be able.
With all due respect, John, the holographic statute doesn't require two independent witnesses. It says two witnesses. That's all it says.
Well, let's look at that. That's different than what I have always understood. And I'm not to say I haven't made a mistake in the past. There's a case, State Payne versus the State of Groves, Tennessee Court of Appeals, September 6, 2024, that the head note says, in a petition to establish a lost will, the handwritten script met the requirements for a holographic will under this provision because the testimony of the two disinterested witnesses supported the conclusion that the decedent intended the script to be her will until she was able to execute a formal will. Mr. McNabb, I'm going to allow it in based on the testimony of these two witnesses, but if there is a contest of the will, it may be that there will have to be two disinterested witnesses. That has long been my understanding of the law, and this case that I've cited seems to substantiate that, but the statute, as you pointed out, in itself does not particularly require disinterested witnesses. It only makes reference to two witnesses. But maybe it's because over the years, I've always understood it had to be two disinterested. So if you want to have both of your clients raise the right hand and let us place them under oath. All right, go ahead. You may proceed.
Thank you, Your Honor. State your name, please, ma'am.
Tanya Flynn Stewart.
And Ms. Stewart, are you the daughter of Linda Markham, who was originally designated as a beneficiary and an executor of this document?
Yes.
Okay. All right. And the two beneficiaries, Linda is your mother, is that correct?
Yes,
And Margaret Brown, they're both deceased.
that is correct.
All right. And have you outlined in the petition the heirs that would receive their benefit?
Yes.
Their children and husbands?
Yes.
And the gentleman to your right is your stepfather?
Yes.
He was married to your mother, Ms. Markham?
Yes.
Okay. He would also take part of her share?
Yes.
Okay. Now, this document that you have provided to the court, are you familiar with the handwriting and the way this lady printed her will? Are you familiar with the printing and the signature?
Yes, I am.
Can you state whether or not you recognize that as all being in her handwriting?
Yes, it is all in her handwriting.
Okay. And Mr. Markham, you filed an affidavit with the court, but you're here to testify. You familiar with Ms. Brown's handwriting and the way she printed?
Yes.
And do you recognize the printing and the signature on that document being the signature and the printing of Ophelia Brown?
Yes.
Okay.
All right, based on that testimony, I will allow this to be admitted as a will of Ms. Brown and appoint Ms. Stewart as the administrator of the estate or the executor of the estate.
And
Have you prepared an order?
I do, and there's one other issue that it didn't bring up, but I'd like to address. this property, the real estate that's owned by Ms. Brown, there's a 10-care Medicare lien. And we've asked in the petition that she be granted the authority also to sell this. We've got a buyer, cash buyer for 200,000. That's right on the money as to what the property's worth. Is that correct, Miss? Sure. And the lien is 170,000 and change. So this is a good buyer and it's there ready to be sold. And we need to get the property sold so we can get this lien disposed of.
Contract for the sale?
I'm sorry.
Do you have a contract for the sale?
We have not signed the contract. We have the offer.
All right,
But we
I'll-
would not sign it until, we were gonna sign it under the previous conservatorship. But she passed away before we could get back to court to settle under that.
I will order that you go ahead and have the permission to sign a contract as far as we just need to have the formality of having a hearing to determine that that is a fair market value of the property. So I will authorize you to go ahead and enter into a contract and then subject to a court approval. All right?
Okay, so we need to get back.
You need to get the contract signed and then we will just need to have a judge approve that it's the fair market value of it.
I brought the fair market value analysis that, with me today.
All right, what evidence do you have of the fair market value?
It is an evaluation that was put together on the property. And I have the agreement. I just haven't signed it. So I also have the contract. The only thing that I need to do is sign it and then proceed. And they are ready to close. It is a cash buyer. As soon as we have the authority to sell it, we're gonna set a closing date.
Right, do you think this is the fair market value or that this is a fair price for the property, even though it's slightly under what the appraisal is or whatever this document is? But do you believe that it's a fair price?
Yes, I do, because it's a cash price. We don't have to pay any of the closing cost out of Ophelia Brown's estate. The buyer, being a cash buyer at that market price, was willing to cover all of the cost.
All right, based on the documents that you produced, I will find that it is in the fair market value and that it is in the best interest to go ahead and sell the property. So you have authorization to enter into the contract and close on the sale.
Okay.
Mr. Doris, if you'll have a seat at that table right there, please. Have a seat behind you where the officer is holding a chair for you. Brady Wilkerson, you may call your first witness. Ms. Doris, if you'll come around to the witness stand, please. If you'll stand, please, and raise your right hand and be placed under oath. All right, thank you. Now you may have a seat.
Okay, can you say your name for the court, please?
Tammy Doris.
And you are married to Mr. James Doris.
Yes.
And you've been married since February 15th, 1980.
Yes.
And you filed a complaint for divorce. You filed a notice with the court that you'd like to have a divorce. Is that right?
Yes.
And everything that you put in that petition is still true today.
Yes.
And Mr. Doris has been out of your home since at least June 1st, 2023.
Yes.
And why did he leave your home in June of 2023?
Because he went wild. He was holding a gun at me and at my daughter, and he was just raising hell.
And did he end up getting arrested that day?
Yes.
And then what was the result of his arrest that day?
he stayed in jail
How long did he stay in jail?
about a couple years.
Couple years. And was he charged with aggravated assault, domestic assault against you as the victim?
Yes.
And then when he got out of jail, what happened next?
When he got out of jail, he went to some kind of a home and he raised hell there. He told his caretaker that he was going to come to the house and kill me and Bailey to get revenge.
And who's Bailey?
My son.
And so did he actually show up at your home at that point?
Yes, at 12 o'clock, November the 8th.
Of 2025?
Yes.
And how did you know he was at your home?
Well, I was asleep and I forgot to lock my front door. I always do. I let the dogs out, forgot to lock it, and about 12:30, he walked in. Scared me because he was just staring at me.
And then what happened?
And then I hollered for Sarah and I hollered for my son Bailey. They called the cops.
And then what happened?
The cops came and got arrested because I had a restraining order against him.
And so you've actually had a couple of restraining orders throughout the years.
Yes.
During the time that he lived in the home prior to 2023, did he work regular or what was his work like?
No, he worked on and off, but he did draw his Social Security.
And did you work regular?
Yes.
And how did you pay for your home or how did you pay the bills in your home?
I worked and paid the bills.
And did your son help with paying bills as well?
Yes, he paid half.
Have you been responsible for the taxes on your home?
Yes.
Homeowner's insurance, you've paid that
I
bill?
don't have homeowner's insurance because he canceled it.
Have you cut the grass, picked up
Yes.
limbs and
Yes.
done those sorts of things for your home? So today, are you asking the court to grant your divorce on the grounds of inappropriate marital conduct?
Yes.
Are you asking the court to award the home and any equity in that home to you as your sole separate property?
Yes.
And are you asking the court to give you that as spousal support and also just because you have been the primary person that's kept up that home?
Yes.
And then, are you asking that any debts in your name be yours?
Yes.
Any debts in his name be his?
Yes.
Are you asking that if you have health insurance, it's going to be your health insurance and he needs to get his own health insurance? Same with car insurance, cell phones, all of that. Anything in your name is yours, anything in his name is his.
Yeah.
That's all I have from her, Your Honor.
All right, ma'am, you may step down. Mr. Doris, I'm going to give you a chance to testify, but because you've not filed a formal answer to the complaint, you technically have not appeared in this case other than those motions that you filed. So I'm going to give you a chance to testify. Do you understand that? All right. Call your next witness. Come on, please. You'll raise your right hand and be placed under oath.
You can have a seat, but be careful of that chair. All right, and tell the court your name, please.
My name is David Doris.
And
Pull the microphone towards you just a little bit. There you go.
and how do you know Miss Tammy Doris?
She is my mother.
And how you know Mr. James Doris?
He is my,
And you heard the testimony that Miss Doris gave?
yes, ma'am.
And do you believe that to be true?
Yes, ma'am.
And you've lived that life, so you know it's true.
Yes, ma'am.
Do you know Miss Doris to be a truthful person?
Yes, ma'am.
That's all I have from that witness, Your Honor.
Well, thank you. You may step down. All right, next witness.
Virginia McIntyre, please.
Raise your right hand.
All right, can you tell the court your name, please?
Virginia Caroline.
And you're gonna have to lean into that microphone a little bit. Okay. What's your name?
Virginia Carol McIntyre.
And how do you know Miss Tammy Doris?
She is my technical mother-in-law.
Okay. And you heard the testimony that she gave?
Yes.
And do you know that testimony to be true?
Yes.
And have you lived a part of that testimony?
Yes.
And you know her to be a truthful person?
Yes.
That's all I have from this witness, Your Honor. And those are all the witnesses I have.
Mr. Doris, I want to address a couple of things in what you have filed that I didn't address when you were on Zoom. Number one, you had requested that I appoint an attorney to represent you, and while you may be in court in jail for criminal matters, in a civil case such as this, you are not entitled to have an attorney appointed for you, even if you're indigent and unable to hire your own, because a civil case does not give you the right to have state-appointed attorney to represent you. So for that request could not be granted. In addition to that, there is no law that requires me to order that you and she try to reconcile. She doesn't want to be reconciled with you. She wants a divorce. And so therefore your request that I order that the two of you try to reconcile your marriage, I will not grant that. I will give you, I know you have filed a motion in opposition. It doesn't comply with the rules of civil procedure to be an answer to this case, to this complaint, which was required. And I'm going to give you a chance, if you want to testify, you can come up here on the stand and you can be sworn and placed under oath, and you can testify about why you oppose this divorce. All right. I want you to understand, if you do that, you're subject to being cross-examined by Miss Brady Wilkerson. She can ask you questions. Stand up and raise your right hand. Stand up and raise your right hand so you can be placed under oath. There you go.
I do.
Thank you. Have a seat. Pull that microphone down. I need you to speak directly into that microphone, okay?
Yes, sir.
This is your opportunity to be heard about the divorce and why you think you should not be granted a divorce.
Well, I still love her, and I'm the one who built that house from scratch. And I'm the one who paid for it. She didn't pay for it by herself. I've had a job and I've had a Social Security check coming in, or a retirement check, where I paid half or more. And we just put it all together. Happily we were. And that's how I got paid for all the bills and what have you. I've worked myself full time and paid taxes. So I just want y'all to know I'm the one who cut the grass, and I'm the one who built that house. And I want to just go back and it be like it was, and not have to sell it. But if I have to, I'll have to sell it, and we'll have to split the money, which I don't want to do. I want to go home. I haven't been home, and it's more than 2 years. It's like 4 years. I haven't been home. And I just want to go home. Simple as that, Your Honor. And I am an honorable man, and I've paid the taxes, and I've done the job. So that not doing anything, I'm a workaholic. I'm the one who cut the grass and cut the firewood for them this winter, for wintertime weather. We have a wood burning stove. It heats the whole house. I built the house where it could stay warm with that one stove. And it's a big house. I think it's 1,000 square foot or more, because it's got a deck all the way around it. And for some reason overnight, she gets up and wants me out of the house. Now, I don't know if it's because I just gave my son the justice of peace or something like that, that honor to, keep me straight and everything. And fact is I shouldn't have done that. I've had people tell me, I kind of shot myself in the foot, but
All right, anything else you want to say?
Well, I love you, Dad. I love you.
You don't talk to her, you talk to me.
Oh, yeah, I just want you to know that I love her and, we can work this out. I just wanted to go to a council of some sort and work this out because I truly do still love her. And, I want her back and I want my home back, which I haven't had in 4 years. I've been in jail, this jail, for 4 years.
All right. Ms. Brady Wilkerson, you want to ask any questions? Why are you in jail?
That's a good question. I've been asking that and no one's told me really why.
You've been asking why you're in jail. You don't know why you're in jail?
No, because I didn't want to get attorney involved and have a big payment of paying an attorney, but I guess I should at first. I wouldn't have been here 4 years. But I guess for whatever I did with my wife, she said I choked her or something. What I did, let me explain this exactly what I did.
What charges?
Yep. Was Judge, I was out on the street.
Wait, I'm going to stop you right there.
Okay.
Because you're being recorded and you're under oath. So if you say something about your pending criminal case, the violation of probation, the district attorney's office can use that to show the judge that you have admitted something that may violate your probation. So don't talk about what that pending case is. Okay? You understand that?
Yes, sir.
All right, step down, have a seat. Ms. Brady Wilkerson, this complaint that you filed does not contain a prayer or a request for alimony. It only requests a property division. And I don't have any proof in the record regarding the value of the house to determine whether awarding it all to her would be an equitable division or not. So I'm going to grant you the permission to amend your complaint to add a prayer for alimony if that's what you wish to do. I'll reserve the granting of the divorce to allow you to do that, and we'll reset it for the 27th of this month. And at that point in time, I need to have some evidence regarding the value of the house and whether there was any debt, and also the evidence regarding that was justified the sort of alimony award. Mr. Doris, I'm going to have another hearing. I'm going to have another hearing in your case. That hearing is going to be designed for me to determine the value of this house and where it ought to be, how it ought to be divided. If she should get it all as alimony, or if it should be divided and give you a portion of it. But I have to have a hearing where that is an issue. And I'm sorry I can't conclude it all today, but clearly there's evidence that would award her a divorce. But in that granting of that divorce decree, you need to provide that I've granted you 30 days to file an amendment. Well, let me give you 10 days to file your amended complaint if you're seeking alimony. So. All right, that's the judgment of the court. We'll see you all again on the 27th.
I don't even know that one.
You're going to get yourself in trouble if you keep talking to them. All right, call the next case. In re the estate of David Phillips. All right, anyone who's going to testify, raise your right hand and let's place you under oath.
Yes.
Go ahead.
Your Honor, we're here today to open the estate of David Phillips, which is the brother of the petitioner. There's we provided to the court the best will we had. It's
That doesn't sound
pretty
good.
embarrassing.
If it's the best will you have.
Yes. It appears to have all that it needs to have, but it's just very ugly. It's a draft. I don't know why it's not the final, but, other than that, other than it being ugly, it appears to be valid. We need to have this submitted because there's some specific bequests to otherwise, people who would otherwise not be heirs.
So you're wanting to admit the will that was sworn before witnesses on the 17th day of October of 2025, is that correct?
Yes.
And this is a photocopy of a draft?
Yes.
But you're saying you don't know why it was never made?
He was working on the will, but his illness progressed so fast that he didn't finish it. Or that's as far as he got.
Well, the will makes you the sole beneficiary, whether there were other, if I saw it correctly, I may not have. Is there any?
Mr. Phillips, he would be the only heir at law, but the will gives some substantial property to others.
But you have waivers of the others that are mentioned.
We
right?
do.
All right. As far as you know, this is the only will of your father.
Yes, sir.
All right. We'll admit that one into probate.
Your Honor,
You have an order prepared.
I don't, but I will send it.
All right. Thank you. I'll grant your request and put it as soon as your lawyer gets your order in, I'll sign it. Okay.
Thank you, Your Honor.
Thank you. Good morning.
From the Nashville Bar. This is our petition to admit a will for the sole purpose of establishing muniment of title to a piece of real property. Angela Eddy is, we represent Cynthia Blanky, the sister of Angela Eddy, who's the decedent, and she was under conservatorship. And she has since died, and we are just trying to transfer a title of her property.
Right. No opposition to your petition. I will grant your request.
I believe there's already an order in the
There
file.
is an order in the file.
Thank you, Your Honor. Good morning, Your Honor. This is my claim to the exception to the claim of Northcrest Medical Center. Your Honor, the only thing I received as far as their claim was this. There's no bills, no invoices, no.
Anyone here from Northcrest Medical Center to assert their claim? No one here. Your exception is granted.
Thank you, Your Honor. Your Honor, that's our petition to appoint a successor personal representative of the estate. This is a very old estate that's been open for more than 10 years. We were here about a month ago on the clerk's motion to dismiss the case or close the estate. We have since filed a resignation from the personal representative who was previously a employee of the Community Foundation, and this petition to appoint Molly Lacker, who is the owner of Sunny Care Services. I don't think that we have, yes, I have her oath here.
Yes, go ahead.
That's the one thing we were lacking to get in the file for today's hearing, Your Honor, is the personal representative oath signed by Ms. Locker. There's just a couple of things that need to be done to finalize this so that we can close it. And The previous personal representative is living in Iowa, and made it impossible to get that accomplished without appointing someone else.
I'm gonna have this oath file, marked file, but you have an order granting your request as a substitute.
If there's not one in the file, I'll submit one today, Your Honor.
Okay, I will grant your request. Obviously, you need to try to conclude it, so if you'll submit an order, okay?
Thank you. There's
Okay.
not one in the file.
I
No,
didn't see
okay.
one, but the clerk may find one. If she does, I'll sign it.
Okay, thank you, Your Honor.
Point out at the very outset that I've got the right docket number on here, but the incorrect style.
Okay.
This is the case that started out with a conservatorship for Miss Page. You were the judge when this was before the court, and we had a conservatorship. She's deceased. Now we have an estate, and we've got this conservatorship, which is not closed and won't be closed until the court orders it closed. I've tried to get with I've called Mr. Temple. I've sent him a copy of the motion. I've told him that the conservatorship needs to be closed, and so we can make an accounting and get whatever assets are into the estate account. And that's what this motion's for. So.
Well, obviously, that would be the requirement of the law, since there's been a death. Party passed away in November 6th of 2025. That concluded the conservatorship by operation of law. So clearly, the obligation is now to transfer that to the estate. I will grant your request to order that the assets, that a final accounting be made and that any remaining assets be transferred to an estate. Has an estate been opened?
What, is there a time limit, Judge, we can put on that for him? Because
time limit?
You know, a date by which he should do this.
I would think shouldn't really be a problem to do it within the next 30 days. So
okay. That's
all
good.
it is to finalize the conservatorship, file a final accounting within 30 days.
Okay,
and
thank you, Judge.
show that those assets should be transferred.
I'll get an order up here. I'm sorry. Thank you.
All right, 30 days from the entry of the order. Put
Yes,
that in there.
yes, thank you.
Good morning, Your Honor. This is a motion for default judgment on a petition to modify a parenting plan. And
You're here on a motion for default.
Mr. Bearden is incarcerated, Judge. He's here in Cheatham County. I think you called his name earlier, Kenneth Mitchell, sorry, Kenneth Mitchell Bearden.
Let me take just a minute to look through the file.
Yes, sir.
They were divorced in July of last year.
That's correct, Your Honor.
He was served on the 28th day of April.
Yes, Your Honor. And there's a restraining order that was granted by Judge Lockhart Mash as well.
Did I understand you to say he was in jail somewhere?
He's here. He's here in Cheatham County Jail, Judge.
Technically, we're supposed to, by Supreme Court rules, at least if he is in custody, we're supposed to at least let him have an opportunity to participate if he chooses to do so. Why is he in jail? Is it because of?
Judge, he has a A domestic assault against his own mother. I think he has a gun charge where he pulled a gun on one of his friends. There's also been some threats to Miss Bearden where he spit on her during one of the exchanges. And then I think that's all set to be heard. You know what the date is?
September.
It's in September. He's got that pending court date on those charges.
So today, what your petition is asking is simply to suspend his visitation.
We have a parenting plan for your consideration, Judge. Basically, what it's going to do is give mom, 100% of the visitation until he's released and completed an inpatient rehab. And then once he's done that, he'll get a Saturday supervised until he can do that for 6 months and show that he can stay clean. He's had a significant drug problem. And then so once he's clean, that would go unsupervised, but then it would be on him to file a petition to modify it further.
All right, well, let's put your client under oath and let her testify to those facts. If you'll raise your right hand, please.
Yes.
All right, ma'am, can you state your name for the court, please?
Hannah Bearden,
All right, Ms. Bearden, you were divorced when?
July 1st, 2025.
Okay. 25? Yep.
Yeah.
Last year.
Yep.
And then, as part of that divorce, there was a parenting plan?
Yes.
And since that parenting plan was entered, there's been a material change in circumstance, right?
Yes.
All right, can you tell the court a little bit about what has changed since then?
Sure. My ex-husband has a severe drug issue and problem and we've dealt with it for a decade or more, and I dealt with it in our marriage. And I divorced him due to multiple drug issues. I've had restraining orders and orders of protection throughout the marriage. So since July, in the short period of time, July to November, when he was incarcerated, he pulled a gun on his friend, evaded arrest, had a domestic assault against his mother, and continued to threaten me while incarcerated. And that's what,
And Ms. Bearden, since you were divorced, he's had a relapse of his drug problems.
correct.
And so for a period there, he was clean, and then he's had a significant
Correct.
relapse and led to all these criminal problems.
Correct.
And you've had issues during your exchange of
Yeah.
children. He
Yeah.
spit on you during one of the exchanges.
Showed me.
He shoved you. He sent you threats via text messages.
Yes.
He sent you messages that were incoherent.
Yes.
And even after being incarcerated, he was sending you messages from jail.
Yes.
And then we had to get a restraining order from that.
Yes.
And that was granted.
Yes.
And then you've got this parenting plan here for your children.
Yes.
You have 2 girls.
Yes.
And you feel that this parenting plan is in their best interest?
I do.
And that this parenting plan would keep them safe until he can get his drug problem under control?
I do.
Around this, my proof.
You have a proposed parenting plan? that
I
you-
do, Judge. I have a proposed parenting plan and I have a default order if you.
Oh,
And then, Your Honor, if you'd like a final order, I can add that after.
Let me just review this parenting plan. for a second.
Of course. Thank you. And Your Honor, I would like to point out, there's no child support in that parenting plan. One, because he's incarcerated, but also Ms. Bearden makes a significant amount of money.
Well, once he's released, you can address the child support issue separately if you need to. All right, I have granted the amendment to the parenting plan and I've signed your new parenting plans.
Thank you, Your Honor.
Thank you.
Your Honor, would you like a final order to go on top of that as well?
I think it would be appropriate, yes.
I'll get that submitted. Thank you, sir. That concludes our business, Your Honor. We excuse. Thank you.
Thank you.
Morning, Your Honor.
Good morning.
Andy Pulliam on behalf of the plaintiffs, Urban Capital LLC and MP2 LLC.
Morning, Your Honor. I'm Michael Bly. I'm the Cheatham County Attorney representing Cheatham County.
And Your Honor, I'm Kevin Baltz. I represent Century Communities of Tennessee LLC. We're the defendants.
Well, since I have not had an opportunity to read through your file, you're going to tell me what this is about. I know what the motion is on the docket is to schedule an evidentiary hearing and briefing schedule, and a motion on the motion for temporary injunction.
Your Honor, that's all that we have before the court today is requesting an evidentiary hearing before the court related to the motion for temporary injunction. We were wondering if that's possible to be done on the 27th in the afternoon.
How long do you think that hearing will take?
Probably no more than 4 hours is my estimate. I've only got 4 witnesses, and 3 of those witnesses will be very brief.
Well, 27th is already a fairly full day. That's when I was smiling, because when you say 4 hours in the afternoon, I have a feeling it would be longer than that. So your estimation is that it would be 4 hours?
Your Honor, I will let opposing counsel speak to their.
He says 4 hours. What do you say?
I only have 4 witnesses. One will be no more than an hour. The other 3 are fairly short. So I'm 2 hours at max.
You know, when I was standing in your shoes, I would appear in front of Judge Robert Birch, and he would ask me how long something would take, and I'd give him what I thought was an honest answer. He'd say, turn to the clerk and say, double it. So I'm just, and I have found that unfortunately to be true, as much as I regret it. So I'm not fussing at you. I'm just trying to get an honest idea. It's unlikely I can give you the afternoon of the 27th for a 4-hour hearing, because we've got a fairly full day with some contested matters. So it's probably looking at a different day to have that heard.
That's fine, Your Honor. The only reason I mentioned that is because I knew that the court was here on that day.
I did mention that earlier. What do you, are you available on the 16th of this month? That's just next Thursday, a week from now.
I am, Your Honor, yes.
I'll be out of town, Your Honor.
You're out of town?
Yes, Your Honor. The latter part of next week, Wednesday through Friday.
I'm also unavailable that afternoon.
Well, let me take a break and make some calls. I'm starting in August. My first 2 weeks of August, I'm in Stewart County, and usually there's not a very heavy docket. I may be able to shoehorn you in on one of those days if I can find out. You'll give me a few minutes to make some calls. Okay.
Sure. Thank you, Your Honor.
We'll stand in recess for about 15 minutes. To development versus or whatever it was.
You got it. That's it, Your Honor.
You don't have too many names in it. Council, we've consulted about our timing, and on the 22nd of this month, I have some availability. I have as I said, a Uniform Child Custody Enforcement Act, our telephone or Zoom conference with the judge out of California at 11 that day, but I can start you at 9 o'clock as long as we understand I have to take a recess at about 1:45, and then we'll have the afternoon to finish. So it will be here in this courtroom or in the new section of the courtrooms. They've got the air adjusted now, so that shouldn't be uncomfortable. And my understanding was that we've now also set a briefing schedule for the defendant's briefs to be submitted by Friday, the 17th of this month, and then the plaintiff's brief would be due to be filed with the court on the 21st.
Yes, sir.
If you will send those briefs to my, if they're not extremely lengthy, you can send them to my email, which is the judicial email under my name. And that way I can have an opportunity to review them wherever I am. So hopefully before, I like to read everything before I hadn't had a chance to read what your complaint is about, but I'll have read that before we come back. So anything we haven't addressed?
No, sir.
All right, we'll see you all on the 22nd.
Thank you, Your Honor. Thank you, Your Honor. I'll draft an order.
That's fine. Be careful in Alabama's. My experiences in Alabama are usually at UT games, and that's not a very good thing, so. All right. Next case is Gregory Bryce Baker versus Sheena Marie Raven Wingate. And that is Miss Wilkerson and Miss Shanley. Shanley, can you hear everything okay?
Yes, Your Honor. Can you hear me as well?
Can we turn the volume up on the TV a little bit? There's a remote for the TV separately that you might be able to use. Let me see. We were turning the volume up. You're coming across on a big screen TV here in the courtroom, and we are turning that up for you to be able to be heard more clearly. This is a motion to compel the respondent to allow the father to have unimpeded FaceTime calls with a minor child. Is that what I understand?
Yes, Your Honor.
All right. Ms. Wilkinson, you represent the father, is that correct?
That's correct, Your Honor.
You want to tell me what's going on and why you need this motion to be heard?
Yes, Your Honor. So over the last few months, there have been a lot of issues with the phone calls. The parties just cannot seem to get together on when these phone calls should be taking place. I've talked to my client, and he has suggested Tuesdays and Thursdays at 7 p.m. That would alleviate a lot of the issues as far as what time these phone calls should be made. That allows him time to get home from work. The child's almost 10 years old. The other ongoing issue is that the mother is insisting that her FaceTime, he's always done video calls with his child since the child was 2 years old. Child's almost 10. Insisting that her video on her phone isn't working, but it has no issues when the child's at his house and the child calls the mother. They FaceTime. So I don't know what the issue is there. It would seem to me that if the FaceTime works when it's at dad's house, then it would work when it's at mom's house. The other issue is that the phone calls just simply aren't unimpeded. Mom is right there the whole time. She doesn't let the child go to his room or another room in the house to be talking to the father. In the father's house, the father gives the mother the courtesy of allowing the child to go into the bedroom where there isn't a camera and the child is able to talk to the mother unimpeded. And he's just not offered the same courtesy at the mother's house. So these are the issues that have been going on. I'm just asking for an order that the phone calls happen Tuesdays and Thursdays at 7 o'clock and that they be video chats and that the child is somewhere free from distractions so that the father can actually have meaningful conversation with the child.
Ms. Shanley, do you have any response to that?
Yes, Your Honor, and just for the court, my client is also present. Just so Your Honor is aware, it looks as though father is asking for unimpeded FaceTime calls. Tennessee law doesn't require that he be provided FaceTime calls. He is granted 2 actual calls per Tennessee statute, and FaceTime calls are allowed if available, Your Honor, is what the statute permits. And mother has been very clear with father that she was having issues with her camera, with her phone. That information was provided to father. That information was also provided to opposing counsel. And she has since then been able to fix her phone. Father has been able to exercise FaceTime calls with the minor child. Petitioner also alleges that he's only had 4 phone calls within the last month as of when this was filed. Your Honor, my client goes above and beyond to ensure that father has the opportunity to call the child. Father makes a decision either not to or is unavailable to. We do not have any objection to a set schedule being put in place for FaceTime or for calls in general. Your Honor, we would be asking that the motion to compel be denied just for the simple fact that father is not entitled to FaceTime calls. And even if that were the case, mother has made him very well aware that she was having issues. Her phone has since been fixed. She is typically in the vicinity during those calls. Mother does not interject herself into those calls. If the minor child does sort of revert to her at any point during those calls, she essentially states, please talk to your father about this. So she's not impeding on any sort of phone calls. She's not interjecting herself into any sort of phone calls. And for those reasons, Your Honor, we would ask that the motion be denied, but we would ask that a temporary plan until something more formal is put in place, a temporary schedule be put in place as to a time period for which the father is supposed to call to speak with the child, not requiring mother to call the father. And Your Honor, we would also be requesting that the parties use a parenting app. I think there are some issues with the parties being able to properly communicate. So we would just ask within that order as well, for a schedule that the parties be ordered to use a parenting app as well.
Does either side wish to put on proof about this?
Your Honor, no, because I think we're really kind of saying the same
Doesn't sound like to
thing.
me that you're either one. Let me just say this. The statute may not say that FaceTime calls are part of what is provided for the mandatory telephone call, but where available, this court favors FaceTime calls because it's the next best thing to actually being face to face with your child is to have the FaceTime. So it seems to me reasonable that so long as the technological problems have been resolved, that the father would be allowed to have 2 FaceTime calls during the week with his child. I think the proposal that has been made is we set Tuesdays and Thursdays at 7 p.m. Any objection to that, Ms. Shanley?
Your Honor, I think we had requested to do between 5:30 and 7:30. So I think 7 p.m. should work for mother and the child's schedule. Yeah, between
Did you say
5:30
your
and
client
7.
is here?
Yes, Your Honor, my client is present in the courtroom as well. We had originally requested 5:30 to 7 p.m., Your Honor.
The problem with 5:30 to 7:30 p.m. is that that's a pretty big window that is not definite enough that would allow it. I am going to order that Mr. Baker will be responsible for initiating the call. That way he can set the call, and we just need to set a time that's convenient. Surely your client is here. Do you have any problems with the 7 o'clock Tuesdays and Thursdays? All right. So she's here and she just agreed that 7 o'clock on Tuesdays and Thursdays would be fine if Mr. Baker is the initiating party. So now you got an 11-year-old, right?
10.
10? Okay. All right. Then it seems to me that they're old enough to be able to talk to their dad without you having to be, monitoring it and so forth. So let's let them have privacy when they talk to Mr. Baker. That doesn't mean you can't ever go in the room. It just means that you're not hovering over the shoulder and that sort of thing. I'm not saying you do that. I'm just simply saying I'm putting an order down so that both sides feel like they've been treated correctly and fairly. We're going to let him set the time, and he's now responsible for placing the call. So you have to be available for 7 o'clock. 7:15 rolls around, he hasn't called, then he's waived that call. You understand that? Mr. Baker, I'm giving you that much time. So if you're going to call, you got to call. Now, I would like to think that the two of you could communicate via text message without any issues, but Ms. Shanley was suggesting a parenting app.
My client
I don't
doesn't
have
oppose it.
Pardon?
My client doesn't oppose it.
And let's get involved and go ahead. Yeah, come on up a little closer. Miss Wilkerson won't bite you as far as I know, so.
Both of us have to be responsible and pay for our subscription to it.
Well, I think that's a reasonable thing. So I am going to order that you initiate this parenting app. It just, what it does is it essentially insulates the two of you from having, you wouldn't believe how many of these cases I see where there are text messages that are snarky back and forth with each other, even over things that should be discussed without that kind of problem. So we'll initiate the use of that parenting app. Your lawyer can send the information to Ms. Wilkerson, and she can set that up with her client. But I am going to order that the parenting app be employed. And that way, both of you can communicate without any kind of issues and hopefully start to better co-parent your child. So we've got 7 o'clock Tuesdays and Thursdays. He has until 7:15 to initiate that call. And then if he doesn't call you by 7:15, you're free to go about your business. Now, as a practical matter, 7:16 rolls around and he calls. I'm going to ask you to, I'm not ordering you, but I'm just saying, the common sense would say, give him an opportunity if something's come up and he's running late. But by law, you're going to only be required to wait 15 minutes if he hasn't started at 7. So, okay. Anything else we need to address?
Do they have a preferred parenting app that they want to use?
She
Yes.
has already got that information. It's my understanding that have you given that to Ms. Shanley? Do you have the information on the parenting app?
I do, and I believe, Your Honor, the information has been sent directly to father as well. So I would request, for the sake of the order, that a time frame be put in place for father to get the actually
I would say
download the app.
15 days would be sufficient. Let's get it initiated at least by July 31st. That will give you plenty of time.
Which app is it?
Starting, the parenting app needs to be implemented by July 31st. Make sure you and your lawyer provide that to Ms. Wilkerson. Even if you send it to Mr. Baker, let's send it again, okay? Right.
That should
We're gonna start with focusing on what's best for your child, and it's a girl, is that right? Son, all right. Your son is 10, going to be 11, right? All right. So you have a young man who's growing up. He needs to be involved in his father's life, and his father needs him in he needs to be in his son's life. So let's try to put aside whatever the problems have been in the past. We're going to now get you in a parenting app. He's going to have these Zoom calls at a set time. Hopefully that's going to eliminate some of the issues and things will run more smoothly. Okay? All right.
Thank you.
Ms. Wilkerson, you want to draw the order?
I will, Your Honor. Thank you.
All right, thank you.
Thank you, Your Honor.
Either side wish to make an opening statement.
Briefly, Your Honor, if we could. I represent Mrs. Miles on this matter. And the record would reflect, Your Honor, that the parties were divorced and entered a parenting plan on January 4th of 2024. And the plan reads as follows. They have 2 minor children, Bentley and Shaylin. The mother is designated as the primary residential parent. She has 183 days. He has 182 days. When we are in that parenting plan on page 3, under the other provision, Your Honor, the original parenting plan of the parties stated that the father shall not consume alcohol to excess during his residential time. And that was entered and signed by this court. And that is the law as it relates to these parties. They signed it respectively. My client signed it on 9/22 of 2023. Mr. Phelps signed it at 9/14 of 2023, and then it was thereafter adopted by the court. Your Honor will recall I filed a petition to modify the parenting plan and had a ex parte restraining order issued due to the fact that Mr. Brian Keith Phelps had been arrested, charged, and ultimately convicted of driving under the influence when their party's eldest child was in the car with him. The testimony from the hearing that we held on November 5th on the extension of the order of protection, Mr. Phelps testified that he and his son had gone to a local swimming hole. He had consumed significant alcoholic beverages. He drove with the child, was pulled over by a Robertson County law enforcement officer charged with driving under the influence. And he pled guilty to that, was placed on 11/29 after 48 hours, suspended license, and ordered to only drive a vehicle with an interlock device on it. And he testified to that, and that is sworn testimony that has happened before this court that Your Honor heard. Your Honor heard the testimony, and an order was entered at that point in time that you did not extend the ex parte order that prohibited him having any contact with the children. But you made the following findings: that the petition counsel, I had called the respondent, Mr. Phelps, to the stand, and he testified that he agreed that the permanent parenting plan stated that he was not to consume alcoholic beverages to excess during his residential time with the party's minor children. He testified further that although his consumption of alcohol had been at the time of the party's divorce, such action was the basis, his actions, because he had drank at the time of the divorce, that he understood that that prohibition was put in the parenting plan. That he knew he could continue to drink, but he just could not drink to excess in the presence of the children. He had testified that he had gone to the swimming hole, had drank 8 to 9 beers while operating his truck with the child. He confirmed that he was pulled over. He had a 0.19 alcohol level in his system, which was almost over 2 times the limit. And Your Honor entered the following order: that Mr. Phelps would that the parenting plan would remain in effect, and he would continue to have residential time with his children as set forth in the order, but that Mr. Phelps was specifically restrained, enjoined, and prohibited from consuming, possessing, or in any way subjecting the party's minor children to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individuals, including his current paramour, from consuming, possessing, or in any way subjecting the children to any type of alcohol. It's further ordered, judged, and decreed that there will be no alcoholic beverages at the home where the respondent is exercising his residential time. And your order entered that on December 10th after the hearing on November 5th. I had forwarded that was sent. Your Honor held that for 10 days prior to you doing it. At this point in time, Your Honor, I filed a petition for criminal contempt, alleging that he testified under oath that he violated the original terms and conditions of the parenting plan by consuming 8 to 9 beers, having a 0.19 alcohol level, and driving with his minor child, and that was a violation of the original parenting plan. And we allege that was a valid court order, and that he is in criminal contempt at that point in time. I further alleged about the allegations, or the fact that he had pled guilty, and that he was not to drive by the child. On November 23rd, the respondent appeared at the home to pick up the children. He was driving a vehicle without an interlock device installed. The daughter took photographs of that and forwarded those to her mother. And in fact, at the time that he picked the children up on November 23rd of 2025, there was a beverage in the cup holder that she photographed showing a twisted tea. It was in the cup holder within the vehicles, and the daughter, who I think just turned 11 or will be turning 11, photographed that. On December 5th, we alleged that he again picked the minor children up for his scheduled visitation, again driving a Nissan vehicle that did not have an interlock device on it. My client questioned him about why he was driving and why he didn't have an interlock device. And he stated that he had paperwork and suggested that the petitioner take him back to court. That interchange is recorded. Further, on December 7th, the daughter sent 2 photographs of Michelob Ultra that were in the respondent's laundry room. And that is in a violation of the court's order where there would be no alcohol in the home, and that is in violation of the court order. And since that time, there have been at least 7 other occasions that he has violated the terms and conditions by having alcohol in the presence of the children, including this past weekend, where he went to a party where other adults were drinking with the minor children. So we're here seeking a criminal contempt for the ones that we cited in that petition, and we're asking that he be jailed for 10 days for each violation that the court finds.
All right. You wish to respond, Mr. Porter?
Yes, Your Honor, if I may. Your Honor, I was the recipient of the first petition for criminal contempt. And then somewhat perplexed is when I received the second petition, Your Honor, that was amended. Specifically, there are no stated allegations as to which we are seeking to have 10 days for the father to be incarcerated. We're asking for each violation to have a 10-day incarceration. But specifically, Your Honor, under perfect pleading here, we do not have a situation in which I'm certain as to which order we're saying that my client has violated. Certainly, we're not here today on contempt matters that are orders that are outside of this court's purview. This court did, however, make an order stating that, yes, albeit everything that you heard from Ms. Roberts be true from my client. I believe you actually heard it from my client's mouth the last time, Your Honor. Albeit that, none of that is pertaining to what we are here today, where my client is on trial for criminal contempt for violation of the court order that states that he is not to have alcohol in the presence of his children or consume it, Your Honor. When it comes to the idea of not being able to control the world, if you will, Your Honor, a party, a restaurant, I don't know at what point in time your order would, Your Honor, extend to the idea that my client is to remove his children from alcohol at all times. But I would also state that that is not here, again, under this contempt petition today. I would tell you, Your Honor, that what we have is nothing in this pleading pertaining to the fact that the children have told the mother that they have seen father consuming alcohol. Nothing in this petition pertaining to the fact that they have said that father smells like alcohol, that a paramour smells like alcohol, that anyone in the house smells like alcohol, that anyone appears to be under the influence of alcohol, Your Honor. What counsel comes today with is a couple of photographs. Your Honor, they're not in the photographs that I have, the photocopies. I can't make them out. They're in black and white. I don't know where they're at, Your Honor. But we have what appears to be alcoholic beverages somewhere. So I would tell the court today that mother is attempting to incarcerate father for some photographs that were supposedly taken in 2025, I believe, maybe one in 2026. But Your Honor, they were taken by the party's minor child. Surely that leaves me to confusion as to why it is that the minor child feels the need to be photographing things at father's house. If that is indeed what she's doing, I believe it would draw into question some of the issues that we might be having here, where the children are being brought into this case way more than they should be, Your Honor. They are here if the court is so inclined to discuss with them. But it's our position that my client has not violated this court's order in any way. He's not consumed alcohol around these children. He is very well aware of how he was admonished the last time that he was here. He is very penalty for his actions. And Your Honor, I do not believe that he should be found guilty of these contempts.
Robert, you may call your first witness.
Your Honor, the question being, do you want the minor child, Shaylin will be my first witness.
This is the minor child.
Child, yes, Your Honor, she's the one that photographed.
And are you wanting to have him testify in chambers?
It her.
Right.
Her, I mean, it would be up to the defendant.
You have a right to have her testify here in open court, or you can have her testify back in chambers, but.
Your Honor, we're fine with chambers.
All right. Then we'll take her up inside the jury room, so.
Yes, Your Honor, both children are back there.
They're both back there?
Yeah, I had asked, that they just be placed back there before we started the hearing, and it's actually the father's time with the children, and so he brought them, and I just asked, and they politely agreed to have them go back there.
We will retire to the jury room and we'll hear this. Back on the record in Phelps versus Phelps, we've heard testimonies from the children, so we'll now hear from any other witnesses.
Yes, Your Honor, and I just wanted to clarify something that counsel had brought up. I initially filed the petition for contempt, and I filed that on December 15th. Out of an abundance of caution, I refiled it in March simply because we had the hearing on November 5th. I typed up the order. You signed it on December 10th, but it did not get stamped filed until December 15th, the same day that I filed the original contempt. Out of an abundance of caution with a notice issue, because they would have not known on the 15th, the defendant would not have known that the order went into quote unquote effect, because I filed the contempt on the same day that the order was technically made of record. So I refiled it so that there was no notice that the order was not in effect. So that's why it was refiled March 3rd, I think, was
All right.
that was an issue that was done, Your Honor. And I would call my client, Ms. Miles.
All right, ma'am, if you'll come up, please. Raise your right hand, be placed under oath.
Would you state your name for the record, please, ma'am?
Chastity Miles,
And Ms. Miles, where do you reside?
1212 Mount John Road.
And you and Mr. Brian Keith Phelps have two children born of your marriage, is that correct?
Yes.
And what are their names and ages?
Bentley Phelps, and he is 14. He just turned 14, and Shaylin Phelps, and she just turned 11.
Okay. And y'all were divorced by decree of this court, is that correct?
Yes.
And do you recall about when that was?